Good afternoon, everybody. Before we begin, just a little bit about myself. My name is Derrick Hogan. I'm a partner here with the law firm of Tully Rinckey. I've been doing criminal defense. I focus primarily on criminal defense and employment law. I've been doing criminal defense for approximately 15 years now. Started doing low-level traffic tickets and all the way up to high-level murder charge cases. So thank you everybody for coming. Hopefully, I provide some informative knowledge that'll help you moving forward. And certainly at the end, I know that we're going to have some questions in the chat box, and I will try to field as many as possible. Okay, so kind of like I just said, a lot of the knowledge here is based on my experience as a criminal defense attorney, as well as just the experience in and out of court dealing with cases. I do want to give a thank you to one of our law clerks, Maria Jose Macias. She helped me put together this presentation, along with Brittany Adams, who's been kind of coordinating with me throughout this. So with that being said, let's get started. Okay, so let's think about DW, driving while intoxicated, in general. And throughout this presentation, I will be referring it to as DWI, driving while intoxicated. I'm sure you've heard maybe DUI, driving under the influence, whether it's in the news or maybe even in a movie or something of that matter. But in New York, it is codified as driving while intoxicated or driving while ability impaired. So we will be using the DWI acronym. So one of the first things is the initial police observation and an automobile stop. And an automobile stop is lawful only if it's based on probable cause that a driver has committed a traffic violation. Now, what is a traffic violation? Everybody knows a speeding ticket. There's a law where you have to move over to the left for emergency vehicles or law enforcement vehicles flashing lights on the side of the road. But pretty much any vehicle and traffic law violation, which under New York that's codified as the vehicle and traffic law, any violation can result in an initial pullover, initial stop. And so once that happens, then an officer can look to see if there's signs if someone's impaired or whatnot. As it says here, the valid vehicle and traffic stop needs to be predicated upon police observation of any violation of the vehicle and traffic law, regardless of how inconsequential that violation may be in the eyes of the operator. So that's very important in a sense of it's very rare, but if the speed limit's 40 and you're going 45 and you get pulled over, you might think it's inconsequential, but the officer does have a right to pull you over if you're going 45. You might cross the center line for a split second. Once again, it's inconsequential as it may seem, and there's some weight into that evidence that we'll discuss down the road. The officer does have the right and probable cause to pull you over. And I think another thing to add is it's not necessarily just vehicle and traffic violations. If the officer observed you committing a crime or about to commit a crime, he or she does have the right to pull you over. For example, if an officer is sitting outside of a bank and you walk outside of that bank with a ski mask, a gun, and a bag that looks like money, the officer doesn't need to see you commit a vehicle and traffic infraction to necessarily pull you over. The officer does have probable cause to stop you. Something we mentioned here is an unregistered vehicle. You'll notice sometimes that, police officer, they might run your plates to see if your license is suspended or if your registration is suspended or your vehicle's not registered. They can do that while moving. They don't necessarily have to have you pulled over on the side of the road. And by doing so, that does not constitute an impermissible search. If they run your plate and your vehicle is not registered, that does give them probable cause to pull you over. And as it says here, and I'll just read from the bottom, the current test to conduct a traffic stop, police require either probable cause to believe that a traffic infraction has been committed or reasonable suspicion that the driver or occupants of the vehicle have committed, are committing, or are about to commit a crime. So with that being said, If you do commit a vehicle and traffic infraction, the officer does have a right to pull you over. Doesn't mean you're going to be charged with DWI, but they can pull you over. Okay, crossing the fog line. So what is the fog line? Think about if you're on a regular road or maybe you're on a highway. Obviously, you have your middle yellow lines, whether they're double solid or dotted. But then on the right side of the road, and even on the left side, if it's a 2-lane or multiple lane highway, there is a white line, and that is known as the fog line. And those lines are there that in the event of high fog, it allows the driver some additional visibility in those conditions. And the question is, does police observation of this act constitute a basis to stop the vehicle? And the answer to that is yes. But when it comes to the fog line, that is very fact specific. It depends the circumstances and what the driver has ascertained. You'll see that there's a case cited, People v. Rufus. And in Rufus, the court concluded that officers had probable cause to stop the defendant after they observed his vehicle cross the fog line 3 times within a short distance in time. But conversely, if you look at the case under that muster, briefly driving on the fog line did not create reasonable suspicion to justify the stop. So that goes back to what I said earlier about it being very fact specific. If someone is, crossing over that fog line multiple times within a short period of time, or, we've all done it. Maybe your kid's in the car and you're yelling at him and the wheel jerks a little bit, or, unfortunately somebody's looking at their phone and then they look up or they lose control for a brief second. So, which I would not recommend doing, driving while, texting or on your phone, but it does happen. And so that isn't necessarily that quick pullover or that quick crossing the fog line might not necessarily give an officer probable cause to pull you over. Intermittent, in this People v. Davis case, intermittent contact with the fog line did not provide reasonable suspicion. The court held, here we decline to hold that a fog line encroachment can never be the basis for a valid traffic stop as a matter of law. However, we are mindful that Flutie only testified as a brief contact with the fog line prior to the stop. So once again, that's a case where the touching or the going over, the crossing of the fog line was very brief. And in that, the court ruled that was not sufficient probable cause to pull the individual over. And just something to think about in general, kind of going back to this slide and the last slide, it's that, we do have somewhat of an expectation of privacy. There are vehicle and traffic laws, but law enforcement cannot just pull you over for any particular reason. Now, once again, we're talking about under the law in practicality, and in practice, have officers probably pulled over individuals for myriad reasons that are not reasonable? Yes. But under the law, an officer can't just pull you over. So there needs to be probable cause for that pullover. In the People Bordeaux, crossing a fog line a single time for approximately 3 seconds did not rise to reasonable suspicion, warranting a stop of the vehicle. And once again, it's really fact specific. And that's something you can ultimately challenge. Every time we talk about these things, and we'll certainly dig deeper into them as we move forward, is that a lot of times what you're learning here today is ultimately going to lead to something you're trying to suppress. Because obviously, if an individual is pulled over and in actuality they are intoxicated, then they're going to be rightfully charged and they're going to have to face the consequences of that. However, police, law enforcement, they also have a job to do. They have to do things right. They have to do things by the law. They have to do things correctly. So if anything, if law enforcement doesn't follow a certain procedure, doesn't follow the right steps, then what is the result of those incorrect procedures, incorrect steps, could lead to suppression of whatever evidence they obtain. So I think that's something to think about today is, obviously, if individuals pull over and they are intoxicated, they do have alcohol in their system, they shouldn't be doing that. They shouldn't be drinking and driving. But to be convicted under the law or to receive those penalties that come along with a DWI conviction, it's imperative that law enforcement and ultimately down the road a prosecutor that prosecutes your case he or she is going to have to follow the correct procedures. Okay, roadblocks. So I think roadblocks, it's good that we're talking about it today with Memorial Day coming up. I can imagine, I mean, I don't know for sure, but I would bet if they haven't already that the New York State Police or some type of local law enforcement agency has already sent out an advisement that they're going to be conducting roadblocks, road checks this week to detect individuals potentially being under the influence of drugs or alcohol. You know, it's usually around a major holiday, Memorial Day, 4th of July, Thanksgiving, all those type of major holidays. You're going to see St. Patrick's Day because there's a lot of drinking related to St. Patrick's Day. So you'll probably see law enforcement out and about. So certainly be careful this weekend. You know, I think it goes without saying if you are driving or if you have been drinking or you are under the influence, it's always a good idea to get an Uber, get a Lyft, get some of rideshare, get a taxi if those are still around, and try to avoid any of this. But I digress. So with roadblocks, roadblocks are constitutional. Technically, they are kind of a warrantless search and seizure because, you know, you're just driving along the road. You don't need to have committed a vehicle and traffic violation for law enforcement to have a roadblock. However, the roadblock has to be operated under very limited circumstances and for a very specifically defined purpose. And that purpose must be known by all officers involved. So, you know, as it states here in City of Indianapolis versus Edmond, roadblocks may not be constituted for general crime deterrence. So, like, what does that mean? Basically, law enforcement can't just set up a roadblock because we want to make sure, you know, people aren't committing crimes in general. We want to make sure someone doesn't have drugs in a car. We want to make sure someone doesn't have guns in a car. And we're going to have a roadblock and we're going to pull over and we're going to search people. That you can't do that. It has to have a very, very defined purpose. So for the example here, you know, the roadblock must have a plan and stick to the plan. You pull over every fifth car. If the fourth car is pulled over on a hunch, that's an unreasonable seizure despite the existence of the roadblock. So you have to follow procedure, and the officers involved have to know the procedures and follow them. But specifically, roadblocks to detect if people are under the influence, that is permissible. And that is kind of going back to what I said earlier about it being Memorial Day weekend coming up. Those are permissible. In this example, if roadblock is for registration inspection check, then there is no good cause to go poking around in the trunk. Correct. You know, the officer is going to have maybe some additional reasoning. So if your inspection is valid, your registration is valid, then you're good to go. Even if your registration or inspection is not valid, you know, I would make the argument that that doesn't necessarily give an officer the ability to search your trunk, search your vehicle, search the inner compartments. And that's also fact specific, but something to keep in mind. Okay, so what do roadblocks require? If it has to have a legitimate primary purpose. And here's where I'll kind of get into, okay, well, if it was to inspect for alcohol, or if it was to inspect for your registration, you know, are they going outside that primary purpose? So if the primary purpose is to check license registration, then the roadblock will be constitutionally permissible. However, if the primary purpose is general crime deterrence, then the seizure will not pass muster. Kind of like we said, you know, we can't just say, all right, we're going to pull over every white car that passes because we want to make sure there's no guns or drugs or something like that. You can't do it. Has to have a legitimate purpose. And that's kind of different than traffic stops, where a legitimate secondary purpose will not save the roadblock if it does not have a legitimate primary purpose. So something to think about, and keep this in mind though, you know, it might be a silly example, but let's just say that the roadblock is set up to check registrations, or it's set up to detect drunk drivers, and that is the primary purpose. Okay, if you roll up there in your car and you got massive amounts of drugs and a bunch of weapons sitting on the front seat, the officer is still going to have the ability to search you. That's separate and apart. That's something like it's in plain view, and they clearly see that you have a kilogram of cocaine laying on your front seat and your back seat. You can't just get that suppressed because you're at a roadblock. But for the most part, the officer has to have a primary purpose for that roadblock, and they have to stick to that. Kind of going what I said earlier, that all agents and officers conducting the roadblock must be educated as to the primary purpose of the roadblock and the methodology in executing that purpose. A lack of knowledge can invalidate the entire roadblock and all evidence subject to suppression. Once again, and I think this is going to be a theme throughout today's CLE, is that law enforcement has to follow the proper procedures or things are subject to suppression. So if everybody is conducting the roadblock one way and you have a couple, 2, 3 other officers are not conducting the roadblock as they should, and ultimately you are the individual, pulled over by those non-compliant officers, any evidence they obtain from you potentially could be subject to suppression. The one thing I will add, and as many of you are sure know, is that you make these arguments at a suppression, and it's not always necessarily clear cut. A judge might not rule in your favor, but these are all issues to raise, because as lawyers, what do we need to do? We need to point out every possible thing that we think that can help our client. And I think I learned a long time ago, it's called playing for the fumbles. You want to, not everything's going to be perfect. You want to play for those fumbles. You want to see if law enforcement screws up or doesn't follow the correct procedure. And that's where if you're a good attorney, you will pounce on those opportunities and you will take advantage of, because if you're prepared, they should be prepared as well. But with that being said, they have to strictly comply with the methodology of the roadblock. There can't be any variances. And then kind of going back to the drugs and gun example, that's where, if you see where it says, unless the officer has reasonable suspicion that can be articulated on some other basis, meaning, that's where I was getting at. Like, if you have a massive amount of quantities of a drug or multiple what appears to be illegal weapons in your vehicle, that's going to give an officer suspicion to, potentially search your vehicle for other reasons. If your passenger has injuries and they look scared and afraid, and maybe it looks like they've been physically assaulted. I know these are all kind of out there examples, but there are instances where even if you are stopped and the roadblock, they vary from the primary purpose of the roadblock, they still can search you based on some other articulable reason. This example at the bottom, visual, olfactory, and auditory observations made by a police officer which lead to the defendant's arrest for driving while intoxicated would be suppressed where the stop of the defendant's vehicle was conducted as part of constitutionally impermissible police roadblock established solely to deter motorists from soliciting prostitutes in a certain area. So in that case, that roadblock was set up for police to determine if motorists were soliciting prostitutes in a certain area. If they detect, like it says, visual, olfactory, auditory observations that someone's driving while intoxicated, then that potentially could be suppressed. That person might, luck out, because once again, if that roadblock's there, that individual, likely would not have gotten pulled over. They were just there to see if individuals were soliciting prostitutes in that area. So that at that point, you can suppress the, indicators, whatever evidence that they have that someone was driving while intoxicated. Okay, so there are specialized circumstances. CBP, the Department of Homeland Security, Customs and Border Protection, they do have the ability to set up immigration checkpoints to prevent aliens and contraband from crossing the border. CBP authority extends 100 miles from the border. But the big thing with an immigration, we'll call it immigration checkpoint, as long as it's within 100 miles of the border, and the big thing is if an agent determines that occupant or occupants of the vehicle do not have reasonable, they're in the country legally, or they're not carrying contraband and everything's checked, their IDs and whatnot, they need to be sent on their way. CBP officers, Homeland Security officers, don't just have carte blanche to take over and search every inch of someone's vehicle, or if they don't have any contraband on them, or, they have a reasonable suspicion that they don't have any contraband on them, and everything checks out, everybody's legally in the United States, here's my ID, here's my passport, whatever it may be, then individuals need to be sent on their way. Okay, so now the vehicle has been stopped. What's gonna happen? I think we've all likely been through the situation before, not necessarily driving while intoxicated, but whether you're speeding, you're on your cell phone, for whatever reason, your vehicle's been stopped. And an officer is usually gonna come up to your window. They're gonna look at a bunch of different things. Well, first of all, I think an officer is gonna make sure that to protect their safety, they want to make sure there's no handguns visible, there's no weapons visible. That's number one, what an officer is going to do. They're not going to take you out of the car. They shouldn't take you out of the car. But the officer is going to make sure that they are safe. And then once they do that, they're going to start doing their physical observations. They're going to look at your hair, your clothing, your eyes. Are your eyes bloodshot, watery, dilated? Are your cheeks red? Is there an odor of alcohol emanating from you? So those are all things, your speech, those are all things that an officer is going to observe. Because remember, an officer, let's use speeding, for example. An officer's just pulled you over for speeding. They have no idea, if you're under the influence of alcohol. Now, if you're swerving in and out of lanes, you're crossing all lanes, you're crossing the fog line, you're running red lights, things of that nature, then yes, an officer is going to already have a suspicion that you're under the influence. But if you're pulled over for regular speeding, they're not going to know that you're under the influence or have any idea that you're under the influence. So they're going to look for clues. A couple of the other ones mentioned the way a driver moves, the driver's ability to follow instructions, providing the driver's license, the registration. Are they shaking? Are they nervous? And that happens. I think, anybody who's been pulled over by law enforcement, it's not a comfortable thing. Some are more comfortable than others. Some are a lot more uncomfortable than others, justifiably so. So, those are all things. It's not, checklist 1, 2, 3, and then, okay, now I have probable cause to charge you with DWI. Those are just observations that they have to make. So one of the questions is, have you been drinking? Because that is a non-custodial interrogation, they're not required to give you your Miranda warnings. What's your Miranda warnings? You have the right to remain silent. You have a right to counsel. Anything you can't say against you, anything you say can and will be used against you. Everybody knows Miranda warnings. But them asking you if you've been drinking does not require a Miranda warning. However, you as the driver at any time can invoke your right to stay silent or your right to counsel. At the side of a road, I'm certainly not telling you to offer any information in connection to an officer, but sitting there silent, you want to be compliant to a certain extent. At least in my opinion, this is just my opinion, because if you just sit there, hands on the wheel, silent, an officer's going to be suspicious, or if you're just if you're just being a jerk, you're making the officer's job tough, and you could hurt yourself in the future. So obviously, you have every right to invoke silence and not say a word. And certainly, I wouldn't admit that you have been drinking. But I think you do want to be somewhat compliant, because the less you do, I think the more suspicious an officer is going to be. And once again, that's just a personal opinion. It's certainly not based in any legal, it has no legal basis. But the one thing that, and we'll get to it down the road with the breath test as well as here, a driver may refuse to take field sobriety test, FST, that's what the field sobriety test, without penalty, other than a, quote, consciousness of guilt instruction at trial. So, and we'll get to it now and then later, there is something called consciousness of guilt, whereas if you refuse to ultimately take a chemical test back at the station, or at a hospital, whether they draw blood or you blow into a breathalyzer, the jury can be instructed in a consciousness of guilt instruction. Now, that doesn't mean someone's automatically convicted, but essentially, when a jury's deliberating, they can consider that by you remaining silent, or you not necessarily giving in to the breath test or giving in to the blood test, that you do have a consciousness of guilt. Once again, it's not dispositive guilt. Other factors, other elements still need to be proven, but it's something that a jury can be instructed on. Okay, so say you get to the officer approaches, you've been pulled over for speeding, your eyes are a little bloodshot, your speech is a little slurred, you smell like you have some alcohol in your breath. If the officer believes they have probable cause, then they will ask you to get out of the vehicle and they will perform the field sobriety test. And there's some tests that need to be performed, and we're going to go over those. The first is the horizontal gaze nystagmus, there's the walk and turn, and there's the one-legged stand. So remember, you haven't given any, you haven't blown into anything yet, you haven't given any kind of breath test yet. It's just this officer, based on reasonable suspicion, has now pulled you over, and they want to do some field sobriety tests. Okay, the first is the horizontal gaze nystagmus. So they're going to give you, well, what is, and we'll get, I think it's in the next slide, so I'll get into that. What is nystagmus? But what's going to happen is they're going to give you instructions. They're going to say, I'm going to check your eyes to keep your head still and follow the stimulus with your eyes only. Usually it's like a pen with a light on or something that, they'll put right in front of your nose, and they'll ask you to follow it along with your eyes by not moving your head, or your neck or anything like that. Essentially look straight ahead and then just follow the light with your eyes. And there's some clues that you would fail this test. There's a lack of smooth pursuit, there's a distinct nystagmus and a maximum deviation, and then there's an angle of onset prior to 45 degrees. So those are a couple clues to determine whether you quote unquote failed the test. And before we go on to the next slide, I just want to make it clear that just because you fail a test doesn't mean you're ultimately going to be convicted of driving while intoxicated. You could be arrested for driving while intoxicated, but just because you fail these doesn't mean you'll be convicted. Now, did the chances of a conviction go up? Yes, but there are certain things that can be challenged, and as a lawyer, we should be challenging any possibility that could help our client. Okay, so a couple of you might be thinking, well, what is nystagmus? And that's what it is, and I'll just read right from here because I'm not a doctor, I'm not a scientist. It's an involuntary jerking or bouncing of the eyeball that occurs when there's a disturbance of the vestibular system or the oculomotor control of the eye. Horizontal gaze nystagmus, or HGN, refers to a lateral horizontal jerking when the eye gazes to the side. In the impaired driving context, alcohol consumption or consumption of certain other central nervous system depressants, inhalants, hinders the ability of the brain to correctly control eye muscles, therefore causing the jerk or bounce associated with HGN. As the degree of impairment becomes greater, the jerking or bouncing, i.e. the nystagmus, becomes more pronounced. So once again, you're looking at a light, you're asked to look straight forward, you're asked to look at this pen at the tip of your nose and just follow along with your eyes, not moving your head. And the more you are impaired by alcohol, the more you are impaired by a controlled substance, there's going to be a jerking or kind of jumping or bouncing of your eyes, and that is nystagmus. But, with any of these field sobriety tests, it's not foolproof, and there could be other reasons. Number one, this goes to any of these tests, you have to have optimum conditions. What are optimum conditions? It's clear. It's a controlled environment. The temperature is not too hot, too cold. It's not raining. There's daylight. There's all these, or there's sufficient light. So there's always things. If you think of any science experiment, it's in a controlled environment. But when something happens in a non-controlled environment, there's different variables that can affect the reliability of that test. So that's just something to think about with this nystagmus test and the other test. And as you see there, it says tests are never administered under optimum conditions. But I think another thing to also think of is, people have, it says here, maybe they're on a certain medication. Maybe they have a certain cognitive issue. Maybe they have a brain injury or anything. They could have a physical condition that affects this nystagmus. So once, it's not an end-all be-all. Obviously, you don't want your eye to jump when following the pen, but like any other, test, it's not 100% reliable. Somebody else's own physical health could impact that, separate and apart from being under the influence of drugs or alcohol. Okay, so what's the walk and turn? And a lot of these, and the walk and turn and the stand on one foot, they have a lot of instructions. And, something to think about, once again, you're pulled over, you're on the side of a road, there's cars passing by, you're with law enforcement, you're scared, you're nervous, now you're getting a bunch of instructions thrown at you. These aren't, that's not something easy to do, right? Obviously, if you're dead sober and you don't really got a care in the world, not going to be a problem. But even then, some people still get nervous. They could be sober and not have any alcohol, but just the fact that they have to sit there and talk to law enforcement makes them nervous. So, a lot of instructions involved with the walk and turn. They're going to tell you to put your left foot on the line and put your right foot in front of it with your right heel touching your left toe, and you got to keep your hands at the side, to the side, and that's big. They don't want, you can't necessarily use your arms to balance yourself. If you're clumsy like me, you might not always walk straight anyway. But just something to think about when they're giving you these instructions. You have to wait until the officer tells you to start, and then when you do, you take 9 heel-to-toe steps in the line, turn around, keeping one foot on the line, and return 9 heel-to-toe steps. So once again, you're not walking in a big gait, you're just heel-to-toe. And that's not always easy. You don't have to be, under the influence to screw that up. And there's all these instructions thrown at you. And so some of the clues that law enforcement's going to look at, they're going to look at, can you keep your balance? Did you start too soon? Did you miss the heel to toe? Did you use your arms to balance? So those are all types of things that the officers will look at when they do the walk and turn. But just like this, there's problems with the walk and turn. We talked about with the nystagmus test is that these aren't necessarily optimal conditions. What if it's raining outside? What if it's 100 degrees outside? What if it's minus 30 degrees outside? All these different factors. What if the ground you're walking on isn't level? So there's all those type of things that needs to be taken into account if they say you failed the test. Here's another thing. What if there's not an actual line and an officer wants you to walk an imaginary line? Well, your imaginary line might be different than my imaginary line. So there's some difficulties with these tests. They're not dispositive. You might not be on a clean, dry, or flat surface. So always something to consider when you look at these tests. And ultimately, if you're challenging them and say you're taking a matter all the way to a trial, and we'll get into this when you talk about discovery, these are some things you're going to want to pay attention to. We mentioned the instructions aspect. There's a lot of instructions. You're nervous. You're afraid. So a lot going on at that time. So all those type of things, just because you do good or do bad, not necessarily do good on these, doesn't mean you're ultimately going to be convicted of DWI, but they do have the ability to charge you because of it. Okay, and then the last one is the one-legged test. Once again, here's a list of instructions. Don't begin until I tell you. Do you understand? And then at one point, they're going to want you to raise your one leg, either leg 6 inches off the ground, and keep it pointed out. And you keep both legs straight and your eyes elevate, and your eyes on the elevated foot. And then you count out loud, 1, 1,000, 2, 1,000, and so forth. Once again, what are some clues that you quote unquote fail? The person's swaying, they're using their arms to balance, they're hopping up and down, they're putting their foot down.
Derrick, I'm just going to stop you right there real quick. I'm just going to give out a course code real quick. The first course code is 676273. Again, that's 676273. This is one of the affirmation codes that you will need to put on your affirmation, and it will need to be turned into CLE at tullylegal.com. I will keep it on the screen for another minute.
Okay, thanks, Brittany. And with the one leg stand, just like this nystagmus and the walk and turn, it's not always reliable. Once again, we keep talking about optimal conditions, a clean, flat, dry environment. And then think about, what if someone has a physical ailment, whether they're overweight, they got leg issues, back issues, inner ear issues, that's very hard. That's going to be very hard for that person to stand on one leg. And then the other thing is, the law enforcement is telling you, well, stop counting when I tell you to stop. So if you don't know what you're counting to, you just keep going. That raises a level of anxiety. And there's all these different instructions. So just remember, these aren't fail safe. They're not 100% reliable. I think it does give them enough probable cause. But these are types of things that law enforcement is going to look at to determine whether or not they're going to take it a step further and ultimately try to get your BAC, your blood alcohol content. Now, the other thing is, I think the one big thing on this slide is the bottom point where it says the value of physical condition coordination test diminishes with the passage of time, and test results eventually become entirely meaningless when they follow a prolonged delay. So, if you're pulled over at some point and then there's a unreasonable delay in them having to do these tests, those tests have less and less weight, reliability than they normally would if there's a reasonable amount of time that follows between when you're pulled over and when you're asked to participate in these tests. Okay, so here, because I know there's a couple more slides I want to get to, and we have about 20 minutes or so. Once again, the reliability of field sobriety tests, they're not 100% reliable. I think when you look at them together in connection with other factors, other evidence that individuals, yes, can be convicted of driving while intoxicated. But once again, standing alone, they are not enough to convict an individual of driving while intoxicated. Okay. And yep, I kind of touched on this. So as everybody knows, or if they don't, that New York has had revised discovery laws. I want to say around 5 years back. Don't quote me on it. So now pretty much anything associated, with your case that the prosecution relies on, or will try to use against you, ultimately at a criminal trial, must be provided to you through automatic discovery. And one of those things is, in New York, law enforcement needs to wear a body cam. So this is where, we talk about, well, the officer says I didn't stand on my leg and count, or the officer says I missed a heel to toe. Well, now they got body cam, and they got to disclose that. And they have to have their body cam on, and they have to provide you. So if Officer A and Officer B are there performing the field sobriety test, and they either write in a report that you did something, or trying to testify under oath that you state you did something, this is where discovery comes into play. The body camera footage, all these reports that you need to go through with a fine-tooth comb to see whether they, in fact, are telling the truth, or in fact, you did do something like that. So basically, and it says it right here, the footage can give you the ability to dispute the officer's observation both before and during the field sobriety test. Hey, you didn't stand on, I told you to count to 5, you only counted to 3, and then you dropped your leg. Well, then you look at the body cam, and you did stand on your one leg until you counted to 5. So something to think about. And that just doesn't go to body cam. It's any report, document, instrument used that they intend to use against you, or they use to charge you. Everything needs to be looked at. Everything needs to be scrutinized, because once again, our job as lawyers, do what we can for our client, inspect every possible outcome to determine if we can help them. And I think this little blurb about discovery, it just doesn't relate to driving while intoxicated cases. It relates to any kind of criminal charge. They have to produce something. They want to prosecute you. They want you to be incarcerated, fined, on probation. They need to follow rules. They need to give you all your evidence. So just something to keep in mind when we talk about discovery. Okay, the portable alcohol screening device, PBT, I call it pre-breath test. This is a device that essentially, it doesn't register your BAC, your blood alcohol content, but it is something that you could, sometimes people refer to it as a roadside breath test. An officer can ask a driver to submit to an alcohol screen to determine whether the driver has been drinking. It's an integral piece of probable cause, but it's not, a failure at this level does not invalidate everything. Okay. You can't necessarily even admit it at trial. And I believe, if I'm not mistaken, if you refuse to take this PBT test, it's just a traffic ticket. It's not if you ever hear of a chemical refusal or, a DMV refusal hearing, those aren't the same thing. It's just to determine if the individual has alcohol in their system. It's not probative of intoxication, and the results are not admissible at trial. So, once again, it more leads to the probable cause. Does it mean that, you know, Jimmy Jones or Sally Jones has been convicted or should be convicted of driving while intoxicated? No. But it does go into that probable cause. And if you kind of see the things we've talked about throughout the class today here, is that it's all what builds up to the probable cause. Okay, you got pulled over. Then you, displayed signs of impairment. Then you failed some field sobriety tests. Then, the PBT test determined they have some alcohol. So all those things, while not dispositive themselves that an individual is driving while intoxicated, used as a whole, gives the law enforcement, gives prosecution knowledge or the ability to determine that they have probable cause to charge you and ultimately attempt to convict you. Okay, so now you failed some field sobriety tests. Maybe the PBT indicates that you do have alcohol in your system. Then at that point, an officer has probable cause to believe that you committed an alcohol-related offense and can place you under arrest. At that point, that's when the 2-hour implied consent clock starts. If a driver is suspected of violating Vehicle 1192, Vehicle Traffic Law 1192, which deals with driving while intoxicated offenses, and is involved in a fatal or serious physical injury crash, you can get a court order to apply for and secure to compel a blood draw. Because if you think about it, an officer can't just come up to you with a needle and stick you and say, I'm going to take your blood. You do have an expectation of privacy. However, under certain circumstances, there can be a compelled blood draw with a court order. There's no requirement that a blood or breath sample be taken within 2 hours of the arrest. And if a sample is taken 2 hours after, there is no basis for the suppression of the evidence. Excuse me, if it's taken within 2 hours, there's no basis for the suppression of that. There could be other reasons to suppress it, but that alone is not a basis to suppress the evidence. At the end of the 2 hours, still, the police can request a sample, but a driver can invoke their right to counsel. I want to have my attorney present, or I want to speak to my attorney before I give consent. So that's always something to think about. You got to pay attention to warnings. Should the warnings misstate the consequences of refusing or be illegally inaccurate in any way, the results of the chemical breath test could be suppressed even if a defendant consented to take the test outside of the statutory 2-hour implied consent clock. So, what does that mean? Because I want my attorney. Well, you can still invoke your silence, but it's to pay attention. We talked about pay attention to the fumbles. Does the officer misstate the consequences? Does the officer not tell you that, hey, if you don't give this test, it could be, I don't think they're going to tell you it's a consciousness of guilt and jury instruction, but they can advise you of consequences by refusing. One of the things is if you submit to a chemical test, that could be used against you in an administrative leave revocation hearing. So that's something to think about. With the DMV, New York State DMV, you can refuse a test at a police station, and you can ultimately go to your trial and you could win. However, DMV, Department of Motor Vehicles, who issues your licenses, that is a little bit different. That if you refuse it, you pretty much could have your license revoked for 1 year. So you refuse the breath test, the chemical test, I should say, at the station, and ultimately you go to trial. You're exonerated of any charges in connection with that. Then you go to the DMV, you have a hearing, and the hearing officer says, well, you refused, it wasn't valid, your license is going to be revoked for a year. So something to think about in that context. Okay, the breathalyzer. Where the officer lacks probable cause to suspect that the offense of driving while intoxicated has been committed, imposition of the breath test constitutes an illegal search and seizure of the motorist's breath. I think that's pretty straightforward. Officers can't just go around giving you breathalyzer tests. And when I say breathalyzer, remember to differentiate between a breathalyzer, I like to call it a chemical test, versus the PBT, the pre-breath test, where it's on the roadside just to determine whether you have alcohol in you or not. You do have a limited right to counsel. A defendant who has been arrested for DWI but has not yet been arraigned, that's something key, or an attorney hasn't made an appearance, has a limited right to counsel to speak with an attorney before deciding whether to submit a chemical test. If the defendant requests the opportunity to speak with an attorney and there's no danger of delay in the administration of the chemical test. That's something, though, where people need to be careful about. You can't just, well, I demand an attorney and I'm not doing anything until that attorney gets here. Well, yes, everybody has a right to counsel, but law enforcement's not going to go above and beyond to get you an assigned counsel. So I think this more applies to if you have, a friend, a colleague on standby, you have your own personal attorney. Yes, the police have to make a reasonable effort to contact that counsel to give you the ability to discuss that chemical test with your counsel prior to giving the test. However, they're not going to call up the public defender's office if you don't have an attorney at 2 in the morning and try to get you an attorney. You don't necessarily have a right to that. They just have to make a reasonable effort. I've heard a lot of times, an officer will say, well, who's your attorney? Give me his or her name. And then, they'll reach out. But it does have to be reasonable. And you see here the one note that remedy is suppression of the chemical breath test. Since the test was begun after a counsel appeared in the case, that's pertinent. It's not like you don't have an attorney yet. Counsel's already appeared in a case. There's no evidence that the police made any efforts to notify the defendant that counsel had appeared, and the people failed to show it was reasonable to do so. So, police can't unreasonably deny you your right to counsel, but they're not going to call your attorney if it's 2 in the morning and your attorney doesn't answer. Too bad for you. They don't have to go above and beyond to contact that attorney. Okay, this talks about Henry's Law. Henry's Law, and I know we have some other slides, so I want to just kind of jump through this quick. Henry's Law deals with, and I'm not going to get into it because I'm not a scientist. It basically deals with how they measure the blood alcohol content in your system through a breath test. If anybody has any questions about Henry's Law, I would say read the slide, do a quick Google search. But essentially, it deals with how an instrument determines that you do have alcohol in your system. Okay, breath test discovery. This kind of goes back to what we said when we were talking about body cam and the field sobriety test. You have the ability to get any documentation that challenges the reliability and accuracy of the breath testing machine in a prosecution for driving under the influence. So if you think about it, there's this machine that's been sitting at a trooper barracks, or it's been sitting in a police station. How many times has it been used? How old is it? Is it calibrated? Do they do inspections? It's no different than, say, like your car. Your car has to pass certain inspections. You buy a car in year 2020, it's probably not going to run the same in the year 2025 unless it has its inspections, unless it has some maintenance on it. So those are all things something to think about when you're trying to attack a BAC in your case. So if you have a BAC of, say, 0.12, 0.09, the legal limit in New York is 0.08. Those are all things that you want to try to consider, specifically testing the machine. You want to test officers to see if they're following the procedures. You want to get their body cam. Well, the same thing. It's important to look at all these reports. If a machine hasn't been calibrated or hasn't, undergone testing of itself, then that's an issue. Another thing is with these breath test machines is they have a control sample. Okay, once again, any science experiment, you got to have a control. And that control sample, and I believe it has to be plus or minus 0.01 above 0.08. So if the control sample is a 0.07, if the control sample is a 0.09, then you have a valid control sample, and then your sample can be measured based on that. It's basically saying, here's a control sample. Yes, this machine's working properly. But if you have a control sample that registers a 0.12, well, that's an issue. And because that is not within the limits it should be. The control sample is supposed to be what? The perfect sample. So if they're going to compare, or they're going to test this machine, or they're going to test you using this machine, those are the types of things that need to be looked at, need to be scrutinized, and certainly need to be challenged if you do want to not be convicted of driving while intoxicated. Okay, so what's the next stage? And I think this is the last slide here, and then I'll try to get if we have any questions at the end here. But as I stated, the legal limit in New York is 0.08. If you are above 0.05 and between 0.05 and 0.08, you can be charged with something called driving while ability impaired by alcohol, which is just a violation. It's not a misdemeanor. It's not a felony. If your blood alcohol content is 0.08 or more, in New York, you could be charged with driving while intoxicated. If your BAC is 0.18 or more, it can be charged with aggravated driving while intoxicated. And I think something to keep in mind, and people get confused, essentially, at least in my mind, once it's over, your BAC's over 0.18, it doesn't matter. It's going to be aggravated. And that doesn't determine, people will say, well, oh, I had a felony BAC. There is no felony BAC. So driving while intoxicated, whether it's aggravated or regular DWI, those are misdemeanors. People are charged with felonies if they have prior convictions within 10 years. So that's something I always, kind of run into. People think, your BAC's 0.24, which is 3 times the legal limits. Oh, that's felony BAC. That's not true. You're only getting a felony. You're only getting charged with a felony if you were previously convicted of a vehicle and traffic law 1192 charge. Another thing to think about is we talked about, obviously, if your BAC is above 0.08, you can be charged with driving while intoxicated. Another thing is what I call common law DWI, which is under vehicle and traffic law 1192.3, meaning you pull over, the officer observes certain things of impairment, you fail your field sobriety test, and then you go to the station and you outright refuse the breathalyzer, which is your right to do. There's consequences of that, but it is your right to do. You can still be charged with driving while intoxicated. Well, you can say, well, how can I be charged with driving while intoxicated? They didn't get my BAC, but there is common law DWI. So 1192-2 deals with having a blood alcohol content of 0.08 or more, and 1192-3, common law DWI, is where you can be charged with DWI without submitting a chemical test, a breath test. So things to keep in mind, and that makes it might be a little bit more difficult to prove their case if they don't have a BAC. But once again, if you don't blow, there can be a jury instruction ultimately about consciousness of guilt, meaning, well, I didn't blow, I didn't provide my BAC, I didn't provide a breath test because I was intoxicated. I knew my BAC would be above the legal limit. So there could be a consciousness of guilt instruction. I think that is the last slide. I might not be mistaken.
We got the second course code for the day. It's 146431. And that's 146431.
Okay, so I know we got a couple minutes left here. So just, I think some parting comments I will give everybody, and I think everybody probably knows this already, but, obviously in today's day and age, driving while intoxicated, obviously you don't want to do it, and you don't even have to do it. There's plenty of ways to get around these days with ride shares or, car services or what there might be. And I've actually seen a lot less, driving while intoxicated, charges these days. But obviously, it's just not worth it. And something to keep in mind because of the multiple, if you drive while intoxicated, you're not only potentially putting yourself in harm's way, but you're potentially putting a lot of other people in harm's way. There might be a kid, there might be an adult, there might be somebody's mother, brother, or sister that you get in an accident with, and potentially something bad could happen. So in today's day and age, there's really no reason to drive while intoxicated. Something to keep in mind. And here's the other thing, because if you do, you're going to have to hire a lawyer like me, and you're going to have to pay a bunch of money. And, that's just something you're coming out of pocket. So everybody, I appreciate your time today. I hope this was informative. I hope you, learned a couple things. Have a safe Memorial Day weekend. Watch out for those roadblocks that are legal. And I thank everybody for their time today.